Bilecki. I'm here with Michael Waddington with another episode of the Military Law News Network.
It's been, again, a busy week, a busy month in terms of military law news. And what we're going to try to do in this episode and in future episodes is limit the episode to one specific topic per episode so that our viewers can quickly get to the meat of what's going on in the news in terms of military law and court-martials. Tim, what's this week's topic that you wanted to discuss?
Well, I'd like to discuss the President's recent comments that have been affecting all of the court-martials. This was in the Wall Street Journal, the New York Times, the Stars and Stripes. Everyone's been reporting on it. Essentially, the President of the United States gave a handful of speeches. The one in particular was done at Annapolis. It was a graduating class. And in this speech, the President basically said that they will not only hold all individuals who commit sexual assault accountable, but they must be discharged with a dishonorable discharge. And that was essentially what the President had said. And from there, some smart attorneys got out there and filed a motion saying that that was unlawful command influence. Basically, that the Commander-in-Chief was directing that anyone convicted of sexual assault is automatically given a dishonorable discharge, which you just can't do. It's an unlawful order. And so Commander Marcus Fulton, the Navy judge out here in Pearl Harbor, was the first individual to hear that motion, and he granted it, saying that it was UCI, unlawful command influence. And based on that, what he did is he took punitive discharges completely off the table. Now, that took everyone by surprise, Mike, and after that ruling, there was a flood of other motions that are going on, and judges in all services now have granted these types of motions. Some grant them, but I believe it's Commander Maxim out in the Pacific granted a motion, but his remedy was to give the defense 5 peremptory challenges. There was another judge who plainly took dishonorable discharge or any punitive discharges off the table. So it's a real hot topic. And what I'm seeing out here in the Pacific, Mike, is this is affecting court-martials at the very heart, which is the jury selection process. What's happening is not only was the President's speech given, but also there were other officials. General Dempsey gave a speech. There were other commanders who gave a speech, basically parroting the same thing. And now we have members that believe that if you convict an accused of any type of sexual assault, not just a rape per se, but let's say it's unlawful sexual contact, grabbing someone's butt at a club, that you must give a punitive discharge or a dishonorable discharge. So that's what we're seeing now, Mike, and we're dealing with this in voir dire, the jury selection. And I'll tell you in a moment how it's been affecting trials out here in the Pacific. But looking towards your comments on your take on this and what you're seeing out in your area.
Well, Tim, this is something that we're seeing worldwide. It's just not limited to the Pacific. It's happening in military courts across the country in all the branches of the service. What's interesting is how certain judges are dealing with Obama's comments that if you're convicted, then you must receive a dishonorable discharge. It's clearly unlawful command influence. You can't have the Commander-in-Chief stating what a punishment must be in a court-martial, especially since he doesn't even know any of the facts of these cases. He's talking in general. Well, interestingly, some judges have declared that there was unlawful command influence, and they'll just let you do a little more voir dire when you're selecting the panel, the jury. Other judges have taken it a step farther and limited the punishment, meaning that they've taken the possibility of a dishonorable discharge completely out of the court-martial, which is interesting, because if someone is convicted of rape, then and that judge takes the dishonorable discharge off the table as a remedy to the unlawful command influence, then that rapist, if the guy's convicted of rape, would still be serving in the military, at least not punitively discharged. Later on, they can be administratively separated. However, they would not get a dishonorable discharge. And to explain to our listeners, if there is unlawful command influence, really the big question is that the judge is going to ask, what do you want me to do about it? And many judges are not willing, very few judges are willing to just outright dismiss the case unless the unlawful command influence is so bad that that is the only option. They'll usually try to find some, in law we call remedy, like how do you fix the problem that the President caused by these comments. And we're seeing some disparity in how the judges address and fix the problems. And from what I understand, Tim, in one of your recent sexual assault cases, because of these comments, you had gone through over a dozen or 2 dozen jurors that you found or that the judge found to be tainted and couldn't sit on the jury. You want to talk a little bit about that?
I do, Mike, and unfortunately at this time I can't go into the facts because the case is ongoing, so I can't go into the facts of the case. But let me tell you what's happening. This is in particular at 25th Infantry Division and 8th Theater Sustainment Command in Hawaii. So it's the Army in Hawaii where I'm seeing this, but I have no doubt it is across the board. It's just where I'm seeing it in particular. The Army had it was Sexual Assault Awareness Month, and that was in June. So what the Army did in all their wisdom, knowing that this could be a potential problem, they mandated that every service or every soldier from E1 all the way through 06, or actually even general officers, go through particular training. As part of the training, one of the issues was they had to watch the movie The Invisible War. And for any of our viewers who haven't seen this movie, I frankly recommend that you go out and watch it and see how ridiculous that movie is and the propaganda that movie is. But that was the training as part of the sexual assault. And then they had discussions on the Invisible War, and then afterwards, and this wasn't across the board for the Army out here, but many members were even saying that as part of the training, they watched parts of the speech, where part of the training in sexual assault was to watch the president's speeches and say, basically, and I'm paraphrasing here, Mike, that the commander-in-chief is demanding that you take action, demanding that you don't turn a blind eye, demanding that you dishonorably discharge everyone who is convicted of sexual assault, and then they expect to, then these same people are on the jury. So what was happening as we were going through the jury selection was we had panel member after panel member after panel member, and these were sergeant majors, full-bird colonels, saying that I don't care what the evidence is. If I convict him based on what's on the flyer, I'm going to give him a dishonorable discharge because that's what the president wants, or that's what I'm hearing. How can I separate that? And so because of that, and then for a whole host of other reasons, we went through every single member that the CG selected, every single one, to a point where there were no other members, and they had to continue the case.
So basically, because of these comments made by the president in the sexual assault training program, it basically tainted the entire jury pool, is what you're saying?
It did. Now, another interesting note, what's also interesting is the way the commanding general gave a fair and impartial jury. One of the members on the panel was the Command 27 Delta, or Command Paralegal for U.S. Army Pacific. So he was in charge of basically all of, even the court reporters and everyone else. Multiple SARCs, Special Assault Response Coordinators, a 17-year law enforcement veteran, another individual who was an MPI investigator, other individuals who were known to have roles in sexual assaults. So that also didn't help the fact either, Mike, that they intentionally gave us what I believe tainted jurors and biased jurors. Once you added that with the fact of their own sexual assault training, there was no one left. After 2 days, or I think it was 2 or 3 days of jury selection, we had 2 or 3 jurors left. And so go ahead, Mike.
And what you're describing right there with the SJ office, I mean, SJ is supposed to pick a fair and neutral panel. I mean, that's really what their goal is. When they go and advise the convening authority on who they should select, they want to have a panel, a jury with enough people that are not biased, so the court-martial can go forward. But I have personally been involved in cases in different branches of the service, including the Army and Air Force, really in particular, where they have taken the jury, and if you have a guy accused of sexual assault that is African American, Black, Asian, whatever, Hispanic, the jury will basically be all people of the opposite race. Number one, I had this happen in a case about 2 months ago, where instead of looking at the demographics of the base and saying, the jury should be a little more diverse in terms of the different, Hispanic, different races of the people that actually work on the base in the jury pool. No, they're all the opposite race, and it's like I had a case where it was 70% women, where the actual number of females on the base was about 20%, and of those people, of the women that were on the jury, about 50% of them either worked directly with sex assault prevention or were victims of sexual assault of some nature. And so what we ended up doing, we started with about 15 people in this case and ended up with about approximately 5 because of how they try to stack the jury. Now, thank goodness in that case, the judge allowed us to excuse or dismiss some of these jurors, but I have seen cases where the judge, the judges themselves will try to rehabilitate or try to fix a biased jury member, just so that jury member could sit on the jury, which again creates an unfair trial for your client.
Sure.
And I don't know. Have you seen judges in some of your cases, Tim, trying to, what we call in the legal business, rehabilitate jurors that have a clear-cut bias, just so the juror could be on that panel?
Oh, sure, Mike. It happens all the time, and we see this all the time. You'll have a juror which say, for example, will say that they were sexually assaulted as a child, or that their wife or their best friend was sexually assaulted, and it still impacts them. You can visibly see that it's impacting them. Your client's charged with the exact same thing. And you know that there's implied bias. You know that there's actual bias there. And certainly, even with a liberal grant mandate, you know that these people should not sit on your jury. But you'll have military judges which will ask questions which are designed specifically to rehabilitate them so they can sit on a jury. Now, it doesn't happen in every case, and it's certainly not every judge, but it goes to a real problem where the heart of a court-martial, for me at least, one of the fundamentals is who's on your jury. Because you can be the best lawyer in the world, you can have the best evidence of the world in the world, but if your jury is all biased and they have a preset conviction, a preset notion that they're going to convict your client, you're never going to win. And so when you have judges that rehabilitate, as they say in the business, or you have training which is done mandated by the CG and by the G3 and the G1 and so on, where you are mandating that people watch The Invisible War, mandating that you are forcing potential jurors and panel members to watch the president's comments, which we know are UCI. It is, in my mind, done tactically and specifically so they can further their agenda and win the war on sexual assault so that an accused doesn't get a fair trial. And the problem is they don't always have solid defense attorneys who know how to pick a jury, who know how to do voir dire. And if that's the case and you get a bad jury, you're never going to win your trial. And I think that is a tactical and knowing decision that's made by Staff Judge Advocate's Office and by commanding generals to stack juries. And that's why in my practice, voir dire is so important, Mike.
Hey, Tim, I completely agree with you. First of all, SJs are supposed to be the best and the brightest of the JAG Corps. And it surprises me how few SJs out there actually know about jury selection, actually have any experience in criminal trials, and it goes right over many of their heads when they know that someone's being shown a video that is clear-cut unlawful command influence. They let that happen, and then they're boo-hooing and don't know. They get upset whenever their entire jury is tainted. And like in your case, they spent all that money flying people out there, witnesses, and they had to postpone the trial, which cost probably $10,000, $20,000, $30,000 in airline tickets alone, simply because people tried to stack the jury, people tried to taint the jury pool. And what I've been seeing, Tim, in speaking, watching cases and speaking to other lawyers, is sometimes if a lawyer gets into the voir dire, the jury selection, and they see the judge, for example, if someone says, I can't give this guy a fair trial, my daughter was raped last week. This is an exaggeration, but something just comes up. My daughter was just raped. I was raped as a kid. I can't give him a fair trial. And then you have the judge come in and be like, listen, can you put that aside and judge this case on its own facts? Will you agree if I order you to be fair and impartial? Will you be fair and impartial? And a lot of lawyers will just sit there and not say anything instead of standing up because they're afraid. They don't want to get the judge upset. Maybe they go in front of that judge every week. Maybe they don't want to, look like they're being difficult. And I'm primarily talking about military attorneys that'll just kind of sit there and let the judge, back the truck up over them and then run them over, them and their client over a few times and not say anything. You have to have an attorney that is not connected to the system to be able to stand up and confront the judge and call the judge out. Because, frankly, as a defense attorney, your job goes to the client. It doesn't go to your loyalty in the court-martial goes to your client. It doesn't go to the SJ. It doesn't go to the judge. Your job is to protect your client, and to do so, do whatever you can within the law to protect your client. And I'm not seeing that happening in some cases.
Yeah, so I guess to sum up this episode, What the president did is, in my opinion, and the opinion of many judges, unlawful command influence. And if you're out there watching the video and you're criminally accused of a sexual assault, make darn sure that your attorney knows about this. They're filing either the appropriate motions or making the oral motions, and that they are getting broad discretion and leeway in voir dire. And voir dire is just jury selection. And as we talked about, again, kind of to sum up, in my opinion, not only is the cross-examination of the witnesses and the closing arguments, that's all the sexy part of the trial, but if you build a house on a bad foundation, the house is going to fall down. And so voir dire, especially in today's military, and that's picking the right jury, is critically important. So you need to make sure that your military attorney or your civilian defense attorney knows how to properly pick a jury, that they're asking the right questions, that they're not going to get bullied by a military judge, that they're not going to get bullied by a staff judge advocate's office. So at the end of the day, when it's your day in court, you're going to get a fair and unbiased jury. Because I still believe, Mike, that that can happen. I mean, in the last 6 of my cases, I think that all 6 of them have been full acquittals. So we're obviously getting fair juries out there, but they don't start out that way. And it takes work, and it takes effort, and it takes, you got to be able to stand up to people to ensure that your client's not going to get railroaded. And I think that's just one more piece of it, Mike.
Yeah, I completely agree with your comments, Tim. And that wraps up this episode. We look forward to bringing you up to date on some of the other news articles, some of the newest news stories that are out there in our next episode. Until next time, thank you.
Take care.
Thank you.